right, we begin here with our big story. Prosecutors now seeking a 30-day delay in the New York criminal hush money case against Donald Trump. The Manhattan District Attorney's Office citing the need to review tens of thousands of pages of newly disclosed documents. The trial is set to begin later this month. Now, this comes after earlier today, the presumptive GOP nominee voluntarily appeared in court in Florida, where his legal team is trying to have the classified documents case against him dismissed. So joining us for more on this is our Florida-based defense attorney and former federal prosecutor Tim Jansen. So Tim, thank you so much for being here with us. So look, it appears it's 30 days, not 90 days. But in terms of this hush money case there in Manhattan, is any delay that he can get a win for Team Trump?
Well, I think it is. And you have to remember now, they're getting 31,000 documents, right? Some of that's going to be exculpatory. You might find witnesses in that you need to subpoena. You're going to need to investigate those documents and prepare for trial. So it's going to be really hard to review 31,000 pages of documents, investigate it, and get witnesses subpoenaed for trial. I do believe that the defense will probably end up asking for a continuance, and they'll blame it on the government for failing to turn these documents over. And if they can deem them as what's called Brady, which Constitution requires them to, the judge is going to have to grant that. And of course, any delay would be helpful to the president.
All right, so now let's talk about this Florida case here. Just moments ago, Judge Eileen Cannon denied Trump's motion to dismiss the classified documents case on unconstitutional vagueness. That was just one motion here. So we're still waiting, of course, for her to make a ruling on the Presidential Records Act. It's a motion about designating these as personal documents. So in your mind, does that first ruling indicate how she might rule on the second one to you?
Well, my understanding from the court observers, she wasn't taking the defense's arguments very good about every president has taken documents out of the White House. If they're personal memoirs, if they're notes, their own personal views, those are presidential records. But if they're actually records from an agency, the Department of Defense or national security, those are not his personal records. And I don't think she's going to find that they are presidential records acts that protect him from those records. We've seen there's classified materials. Normally, a classified material would not be considered his personal memoirs. Although we've seen President Biden has taken some same records and used them apparently for a book. So it's an area that has not really been litigated much, but it's really complex. And I don't see this judge jumping off the cliff if she can find another reason to dismiss the case.
Right. I mean, you brought up Joe Biden, of course. His lawyers brought up Bill Clinton and Ronald Reagan as bringing things home. But as we saw the case play out with Joe Biden, who is not being prosecuted for this, they say the president cooperated when they wanted these documents back. Do you see that as the biggest difference here?
Well, I agree with you. They should have charged him with obstruction, which I think is clear that Biden did not participate in. But the problem you have is the biographer, they didn't charge him with obstruction when he clearly knew that he was destroying records after the special counsel was appointed. Certainly, the actions of Biden and Trump were completely different. Biden told them where they were. He didn't try to allegedly destroy them or hide them. So in that way, yes. But whether they both preserved them and took them without permission, that's the same issue, right? They neither one had permission to have them. And that's what Chapter 793 says. You're not allowed to gather, collect, or lose these documents because they're not your documents.
Right. According to Robert Hur, the biographer deleted a lot of those audio files, and that was something that they were looking into. And again, neither of them facing charges there. I do want to ask you about potentially some of these arguments coming up again, because today Judge Cannon dismissed the arguments without prejudice, which essentially means the defense lawyers could raise these arguments again later on in the case should it go to trial. Do you see that happening?
That's true. Without prejudice means unless you give me more factual evidence that a judge can make a different ruling, because most judges do that. They'll say without prejudice, because there might be something new that might come along that might change my opinion. So of course, the defense will always try to find another reason to change the judge's mind. I think the more important opinion, a lot of rumor is that she doesn't like the selective prosecution. that why hasn't any other president or vice president or other government official been prosecuted under the Espionage Act? That's a little telltale sign she's given out to the court people watching in court.
How so? Can you elaborate on that real quickly?
Well, if she finds selective prosecution, she could dismiss the case with prejudice. If she makes that finding and finds that all these other people, including President Biden, President Clinton, took these records and none of them were prosecuted, and now we have this person being prosecuted. I don't know if she'll jump that far, but it certainly is. By her questions today, she asked, when did this crime start? And it was the day he was still president, right? They charged him January 20th. So effectively, if she finds selective prosecution, that she could find, they could dismiss the case. And that would effectively dismiss count 19 also.
Certainly. Wow. Tim, I know you'll be watching this closely for us, and we'll be checking in with you as this develops. I want to thank you for being here with us today. I want to bring our big story to our panel now. So joining us today is our ABC News contributor and SiriusXM radio host Mike Muse, our former Republican Congresswoman Barbara Comstock, and our former Democratic Senator from North Dakota, Heidi Heitkamp, and our ABC News investigative reporter, Olivia Rubin. Okay, so that was a fascinating conversation we had there. But Olivia, I do want to jump back to Manhattan with you, if we can, for a moment. The district attorney's office seeking a 30-day delay now of their case against Donald Trump because of this new evidence. And Olivia, we've talked about it time and time again, the Trump's team efforts here to delay coming into this election year. How are they feeling right now?
Well, I think you just hit the nail on the head, which is the goal has always been delay, delay, delay. So now this is a gift to the Trump team just 2 weeks before trial was set to begin. And I think it's quite likely that based on what we just saw here, the DA agreeing to a 30-day delay, it's going to lead into another request and another request and another request from Donald Trump's team. Because remember, they're seeking 90 days, not just 30 days. They want a much longer delay, which is no surprise at all. So maybe do they try to go in pieces? They get 30 here, another 30 here, another 30 here. But there's also a bunch of factors at play here. Remember, it's not just as easy as pushing a case 30 days. Does the judge have other things on his calendar? Donald Trump certainly has other things on his calendar, and I think we could potentially see a domino effect with this case pushing back. Because remember, Judge Aileen Cannon, who you were just talking about, is still looking for a new slot, likely for his classified documents case. It was supposed to be May, but now does it have to slide back even further? What is the effect there? So very positive for Donald Trump.
A bit of a domino effect. And Heidi, to you, look, this Florida case, Trump's lawyers name-checked other presidents, as we talked about there with Tim, and essentially they've allegedly taken materials from the White House saying that the only time that the government has taken a different position is President Trump. And you heard Tim Jansen there say that potentially other presidents should have faced the same kind of prosecution if this is going to be the rule. What do you think?
Well, I think that's ridiculous, because in order for his argument to stand, the facts would have to be completely similar, which they're not. Donald Trump had the last clear chance to prevent this kind of prosecution by responding and saying, whoops, I shouldn't have taken them. Here, you can have them back, instead of loading them on planes, instead of trying to cover up the fact that he had them, hide them in bathrooms. I mean, this is not even comparable. And if she decides that this is selective prosecution, in some cases, man, I wish I were a defense lawyer, because if this results in a dismissal, there's probably a lot more egregious cases of selective prosecution than what you're seeing here. So I don't think that argument holds water.
Right, but that again puts the focus on what happened in the aftermath of the cooperation. So, Barbara, to you, I mean, what Tim is essentially saying is that what was done was done. The documents were taken by both people.
Yeah, but I think what he's missing is exactly what Heidi was pointing out, which is that he was trying to get his lawyers to, not go through them, telling his lawyer, hey, can you get rid of them? And then you had the witness 5 who came forward this week saying, he was loading them up to get them out of there at the very same time when Trump's lawyers were coming down there and certifying that everything had already been turned over. His lawyer, Evan Corcoran, who was kind of given that sign, didn't know those documents were being sent to New Jersey. And so now you have this witness also saying that they were trying to get him to, maybe to erase the tape and things like that. So you have a totally different case here.
Well, Robert Hur said, though, that about the biographer, right? He said the biographer tried to delete those files as well in Joe Biden's case.
Well, but if the biographer did that as opposed to being asked to do that by something, again, very different situation.
All right, Mike, actually, I'd love to just get your take and your response to all of this.
Yeah, it's a lot. I think what the part that's missing so far is like the willful ignorance, right? So there is one part that if you didn't know that you took any classified material or you didn't know that you were supposed to return it due to the President's Records Act, that's one thing. But if you have been advised that you have to return these documents, if you have been advised that you have to send them back and you keep refusing, then therefore that argument of not knowing no longer applies. And so I think that is going to be what the special counsel Jack Smith is going to argue to this case and to Judge Eileen, is that he was informed numerous times on the fact that he needed to return.
All right, well, we will see how this plays out. We're still, again, waiting that second ruling there. Mike, Barbara, Heidi, and Olivia, our thanks to all of you.
Hi, everyone. George Stephanopoulos here. Thanks for checking out the ABC News YouTube channel. If you'd like to get more videos, show highlights, and watch live event coverage, click on the right over here to subscribe to our channel. And don't forget to download the ABC News app for breaking news alerts. Thanks for watching.